Hey, Janice.
Hi, Anthony.
Today we will explain how to collect the U.S. account of a deceased foreigner. So we help a lot of non-U.S. heirs collect their U.S. inheritances. So, for example, let's say Aunt Barbara was a UK citizen and she lived and eventually passed away in Spain. But she happened to own a few U.S. bank and brokerage accounts, and in this case, let's say about $200,000. So how do Barbara's surviving nieces and nephews legally go about collecting that U.S. inheritance? It's not as straightforward as you would hope. So we'll try to help you out with a high-level overview today.
Yes, so we will definitely talk about the higher level of, and not go into the nitty-gritty, but we'll talk about step one is going to the local probate court. Step two, go to the U.S. probate court. And then step three is to get U.S. tax clearance.
And lastly, make sure you stick around to the end because I will describe a few of these seemingly simple tasks that can actually cause some pretty significant delays. So you're going to want to watch out for those.
Yes. And then don't forget, subscribe and please comment.
Okay, let me get started. The first step is to go to your local probate court and conduct probate there. And in our Barbara case, she lived and passed away in Spain. So the first step is to complete probate in the Spanish probate courts. That's the original jurisdiction. I hope that's not too legal of a word, but where she lived and where she passed away is where the main probate should occur.
Right.
Exception. If she didn't own anything in Spain, let's say she was a renter and she lived off her U.S. bank accounts, that was her main banking setup, then no, there's a chance she could skip the Spanish or the Spain probate altogether and go directly to the U.S. one. But that's kind of a rare situation. So for the most part, you need to do one where you lived and then one where where the money is. In this case, the U.S., which Janice will talk about now.
Which would be step two. You need to go to the U.S. probate court. You have to bring it into the U.S. It's also known as ancillary probate. Mm-hmm. It's a hard one to say, ancillary probate. You're really getting the court to recognize that the non-U.S. court decision. So you've already gone through step one. Now step two is the U.S. has to recognize that you've started the process with one.
So for example, Barbara, let's say we had Barbara's estate probated in Spain. Now we need the U.S. court to recognize and respect the decision of the Spanish court, which is that's not a simple process. There's a whole procedure to get that done. And once that's done, then U.S. banks and U.S. entities and U.S. parties will be able to deal with and work with a U.S. executor because they have there's no mechanism for Chase Bank or Wells Fargo to recognize somebody who's appointed by a Spanish court, right?
Right.
Okay, so then lastly, so let's say we get all this done and we have a U.S. executor appointed who's ready to go into the bank with his documents showing that I'm duly appointed by a New York or U.S. court to manage Barbara's U.S. assets. There's still one more step. The bank's going to say, not yet. Hold your horses there.
Hold on.
You still need tax clearance. Once you go international, once you have somebody who lives here but is a citizen there or is a citizen of here but lives there, once you get into those types of issues, taxes get a little bit more complicated. And for most brokerage accounts, you're going to have to get some form of U.S. tax clearance before the bank will release the funds. This can mean filing a estate tax return for non-U.S. residents. It can mean obtaining federal transfer certificates. But I mean, to most people, that's all gobbledygook. Just know that you need to get U.S. tax clearance to show to the bank before they will release any money. And I don't mean sending them a copy of your tax return. We've seen people do that. Like, oh, look, I found this on TurboTax. No, there's a very specific procedure to get international tax clearance to get those U.S. funds out.
Absolutely. And you know what I'm hearing from all of this is, could you DIY? Maybe, but this seems like a really good case for a professional because it's complicated. I mean, we do this often and we still have some complications. So sounds like it's a good idea to find somebody that knows what they're doing for this type of situation. But tell us, what are some unexpected things that could slow you up with this whole process, which is probably already a long process? What are some things that could slow it up even further?
So there are a lot of things. I'm just going to give a few off the top of my head. The first one I can think of is getting the exemplified record. All right. So again, I don't want to use legal gobbledygook, so I'm going to try to. Okay, between steps 1 and 2, when you're getting the Spanish court proceeding respected by a U.S. court, you have to get a special copy of the court file from Spain, and that's called an exemplified record. But the problem is, not every country, makes certified copies of the files the same way the U.S. does. And there's this whole back and forth to get it done a certain way in Spain, but then to also get the U.S. court to understand, they don't do it that way in Spain. Come on, just accept it this way. There's a lot of just horse trading with the courts and and with the Spanish attorneys, and it's just a pain. So just be aware that that's not as simple as it sounds. That's really complicated. Getting everything signed by a U.S. notary. So let's say all the heirs are in Europe. My understanding is the U.S. Embassy in London, you have to book an appointment weeks in advance to get an access to the notary. I know that's not the case for all embassies, but I am aware that it happens in some of the more major metropolitan areas. So getting a U.S. notary can be difficult. If you're in a country that's part of a treaty, you can get something called an apostille instead, which is expensive, hundreds of dollars, but you don't have to stand in line at the consulate. So it depends on what your life situation is, what your time is worth. And then lastly, if we're dealing with brokerage accounts, you probably, even after you get your court authority and even after you get your tax clearance, you don't just sign a PDF and get your account out. You have to sign what's called a medallion guarantee to get any stocks out of the United States. And you're probably thinking, okay, what's that? What's a medallion guarantee? That sounds cool. Is that a stamp?
Yeah, sure.
No, it's a pain. It is a pain to get a medallion guarantee.
Expensive, yeah.
Yeah. So it's a special kind of, I hesitate to compare it to a notary, but because it's a stamp, people will think it's like a notary. But just know that only banks have this stamp because they're basically insuring this transaction. And that means they don't do this for just anybody, and they do a lot of due diligence before they'll stamp for you. So it's a fancy, expensive stamp so that you can get stocks out.
But it's required, and you have to go through it. And they're not just looking. So notary, it is like a notary. I always say you have notary here, but then you have the medallion signature up here. And to get to that level, there are so many more things you have to prove and do to get that stamp. So there's a lot of moving parts. We scratched the surface of this is generically how to do it, but it's a pretty complicated process. So definitely one you want to probably look for a professional who's done it before, especially when you're dealing with some of the countries who move backwards instead of forwards when you're processing the paperwork, right? So I think that's it, but please subscribe, leave information and some comments. We'll hopefully talk more, maybe at length, but it's an interesting topic.
All right. Thanks, everyone, for listening. Thank you, Janice, and hope you found this helpful. Take care.